Is West Park Preserve Homeowners Association versus Pulte Home Corporation. Good morning, and I have the appellee's attorneys conferred about how you want to divide your time.
Yes, Your Honor. We've decided 15 minutes for Pulte, 5 minutes for Lawson.
Okay, that works. Mr. Tannenbaum, you're up.
Yes, thank you, Your Honor. I'd like to reserve 5 minutes, although
Sure.
I probably won't need it.
You know, you don't get points off for not using all your time.
So I've been arguing appeals for over 4 decades. This is literally the shortest appellant brief I ever wrote. And the reply brief I wrote was the shortest because the issue is very narrow. This is a construction defect case brought by a homeowners association against Pulte, who is a developer of townhome communities and condo communities around the state. The Pulte's business is to build townhomes and condominiums and sell them to consumers, the public. And the people who are within the homeowners association are just that. They're consumers. The facts are clear that there is a group of homeowners within this community who took title to and occupied their homes within 10 years of the time the lawsuit was filed. So the question is, applying the statute of repose in Florida, whether the circuit court was correct in indicating that based upon that timeline, we're outside the statute of repose. What's interesting about the statute of repose, it has a concluding line, which is the latest of. So it's a four-pronged test. And the cause of action stands as long as one of the prongs was triggered within the 10 years. And the first prong is the date of possession by the owner. The second prong is the date of the issuance of a certificate of occupancy. Because the legislature put all 4 prongs in the statute, means that any of the prongs standing alone could be the latest trigger. And what Pulte convinced the trial court in this case was that disregard the last trigger, the first trigger, which is the date of actual possession. Because what really governs this case is the second trigger, the date of the issuance of a certificate of occupancy. So forget the fact that homeowners took title after that date and took possession after that date, because the last trigger is actually the date of the issuance of the certificate of occupancy, because somehow Pulte was the owner on that date the certificate of occupancy was issued, which frankly doesn't make a lot of sense, because this is the homeowners association cause of action representing each of the homeowners in the community. So if their cause of action is going to be barred, it's going to be barred based upon the last prong applicable to them, which was the date that they possessed. They had no control over the certificate of occupancy. They had no control over abandonment, which is a third prong. They had no control over the date of completion of the contract with the contractors and the engineers and so forth. The only involvement that the homeowner had was to take title to their townhome and to occupy it. It's the only thing they had control of. And what the circuit court ruled was basically that's going to be ignored. And we're going to apply the statute of repose only as it applies to Pulte. Because only Pulte would have been involved in prongs 2, 3, and 4. And the judge said exactly that at the hearing on the motion for summary judgment. And I'm referring to page 56 when he ruled, and the judge said, this is at line 24 on page 56 of the hearing transcript of May 24th, 2021. My review of the statute and the statement of relevant facts that was submitted in the paperwork were left with, as she argued, the certificate of occupancy being a trigger date for the statute of repose. And the court said January 1st, 2009 is the latest certificate of occupancy, and that was confirmed in the Saylor affidavit, and it's undisputed that suit was filed on February 12th, 2019. So I'm going to grant the motion for summary judgment. And Mr. Scrow, who's arguing on behalf of my firm and the plaintiff, questions the judge at page 60. The first is, how is it that the certificate of occupancy was determined to be the last date to trigger an event when the statute states that it could be the actual possession by the owner, whichever is latest? How did the court decide that the CO was a triggering event when the possession of owners was after dates of the CO? And the court said, well, Pulte is listed as the owner on the permit, acknowledgements, special warranty deeds, and there's certificates of occupancy. So Pulte is the owner. That's the owner under the statute. And that's upon that decision by the circuit court is why we're before the court today. What we're asking the court to do is find that the judge's interpretation of the statute was erroneous, that it's the date of actual possession by the homeowner that's relevant, and send it back to the circuit court because that was the basis of the circuit court's decision. We didn't get to the other issues before the circuit judge, which is what are the implications of a portion of the homeowners within a homeowners association having taken title and occupied within the 10 years. What's the implication of the assignments that the association took from those homeowners? What's the implication of the fact that every homeowner in the community, including the ones that were the later homeowners, have to pay for the cost of repairing the entire project? The circuit court didn't reach any of those issues because the circuit court determined that the statute of repose has run as to all homeowners, as to all townhomes, because on the date of certificate of occupancy, somehow Pulte was the owner. Well, Pulte owned the real estate before it developed anything. So if you're going to talk about ownership, I guess by the circuit judge's interpretation, the first prong was already met when Pulte took title to the project before it even started land development and owned the property. It was an owner, and that would make that statute nonsensical. And we've cited the Florida Supreme Court in Baskerville-Donovan versus Pensacola Executive House Condominium Association, 581 Southern 2nd, 1301, decided in 1991. Statutes of limitation, and I consider a statute of repose to be pseudonymous. If there's reasonable doubt as to legislative intent, preference is to allow a longer period of time. The Supreme Court pointed out in that case that statute of limitations bar the enforcement of otherwise valid causes of action. So contractors and developers want to limit their exposure, time exposure. But at the same time, the Supreme Court is on record in indicating that what a statute of limitation does is bar of otherwise valid cause of action. The statute of repose does the same thing. The Supreme Court also said where a statute of limitation shortens the existing period of time, the statute is generally construed strictly, and where there's reasonable doubt as to the legislative intent, the preference is to allow the longer period of time. Well, interestingly, I practiced during the period of time when the statute of repose was 15 years. Then the legislature reduced it to 12 years. Now the legislature has reduced it to 10 years. So according to the Supreme Court's decision in Baskerville, there has been a reduction. Under that case decision, since there's been a shortening of the statute of repose, if there's any doubt as to legislative intent, it's needed to be read in preference to the longer period of time. So I don't think the statute's ambiguous. I think it's clearly occupancy is a trigger, the latest of which would be determinative in this case. And for several homeowners in this community, that trigger was within 10 years of the time the lawsuit was filed. We've cited Allen and Conrad versus the University of Central Florida. But also the Harrow versus Ryland case, which we think is directly on point and speaks directly of occupancy being after the certificate of occupancy was issued in that particular home. In the Harrow versus Ryland case, 277 Southern 2nd, 292, decided by the First District in 2019. Last page of the decision at 299. Appellant does not dispute that the original owners took possession of the home on May 7, 2004, as reflected by the warranty deed, that the certificate of occupancy was issued on April 30th, 2004, and that construction was not abandoned. So in a case by a homeowner against the developer, the First District Court of Appeal, applying the same statute of repose, made a distinction between the certificate of occupancy and the warranty deed, and said that the trigger date.
Mr. Tannenbaum, can I hold you up for a second? And I'm going to pause the clock. It looks like we've lost Judge Case, and so we're going to try to get him back on. And I'm pausing your clock, and we'll restart when he shows back up. How does that sound?
Sounds perfect, Your Honor.
Somehow I thought you'd say that.
We're not going to proceed like meatloaf with 2 out of 3 ain't bad. We're going to have all 3.
I once was in front of the Florida Supreme Court and was asked a question by one of the justices about a potential conflict, and they looked at us and said, "I don't think there's a conflict, counsel. Do you think there is?" And, I didn't have the courage to say yes.
Right.
It was a 4-3 decision against us. So
I wonder how it might have been different if you had said, "Well, absolutely, Justice, there is a conflict." You might have lost 5-2.
no, he ruled against us, but he said, "Counsel, I appreciate your opinion, but I respectfully disagree." But I appreciate your thoughts on the subject.
I think our crack IT people are in contact with Judge Case at this point.
Just 1 second, Judge Northcutt. Sorry about that.
No, thank you, Rita. This is like old home week. Mr. Tannenbaum and I went to law school together. And Mr. Tozier spent a number of years working at our court. So,
And I did know Judge Castanueva when he was a very qualified circuit court judge in Charlotte County. So
yeah, he was qualified then, but
Peter Principal at work.
Peter
right?
Principal.
We were younger than Mr. Tannenbaum.
Yeah, we were.
I was
We
on
were
the
a lot
circuit bench in
younger.
91,
Wow.
and I had to approve a fee order for a private attorney named Steve Northcutt.
Yeah, you'll never let me forget that either.
And poor Mr. Tozier, before he worked with the court, had to survive an internship with me during the summer. Probably turned his hair gray.
Yeah.
Oh, my dear.
I don't know what's happening with Judge Case. And Judge Case sits with us pretty often, so
He sat
He knows the
yesterday, I
drill.
understand.
I think so. Okay, I'm told that he needs to join by phone, so we'll give him a minute to do that. It's magic. We have communications coming, it's like NASA, communicating with me. What's going on with this staff? Pluses and minuses to doing Zoom OA.
the case I was referring to was Trianon Park versus City of Hialeah.
Oh yeah,
Oh, wow.
yeah.
And
That little thing.
I
Yeah,
can't remember the judge, but he said the case was against the City of Hialeah. He said, I used to be the city attorney for the City of Hialeah, and my sister is a sitting commissioner
Oh my.
for on the city commission. And that were and I looked at my partner, Alan Becker, at the time, and I said, what do we do?
Yeah.
And he advised me with his greater experience that when a Supreme Court justice says that I don't think I have a conflict, what do you think? That
Yes.
It's one of those no-win questions.
Absolutely. Absolutely. I remember Alan Becker when I worked at the legislature.
Judge Northcutt,
Yes,
I
ma'am.
believe I have Judge Case on the phone. If you can just let me test it out real quick.
Okay.
Mr. Tannenbaum, I'm glad you didn't have to get on the road today. From my understanding, traffic on I-75 southbound, there was an accident in Fruitville that messed it up for 15 to 20 minutes, plus traffic coming southbound. I don't know how that affects you getting to I-75 to go northbound. But if you're going northbound, I would point out north of Tampa now seems to have a construction or whatever blockage in the morning. My only good news is that I'm going the right way with the traffic in the morning and the afternoon.
Judge Castle pays careful attention to that stuff.
Yeah, all right. Can you hear me now?
Yes.
Yes.
Hello, Judge Case.
All
Welcome
right.
back.
Yeah. My apologies. My neighbor's building a new swimming pool and the backhoe just knocked down the poles in the service.
Oh my goodness.
Oh my.
All right. Well, if you're ready, we will proceed, and I'll start Mr. Tannenbaum's clock back up. And
Okay,
and,
sorry
and,
about that.
and Mr. Tannenbaum, I've got you stopped at 12 minutes and 30 seconds. So just to give you an idea of where you are.
And
I
he was
just,
at the 277 Southern Second site around there in his presentation.
Oh, okay.
Okay.
You ready?
So I was speaking about Harrell versus Ryland Group, which was decided by the First District Court in 2019, 277 Southern 3rd, 292. And it was a personal injury case, but the statute of repose was involved, and the appellate court was determining what was the trigger date And at page 299 of the decision, it looks directly at section 95.11(3)(c) and talks about each prong. And the court looked at the date of possession, which was after the certificate of occupancy, and said that was the date that determined the trigger. So the circuit judge in this case, and his wisdom, determined that that was going to be ignored. The deeds to these last homeowners and their actual possession of the property, and was going to make the second prong the determinative factor. And the statute doesn't support that because the statute says the last of the triggers. And the last case that we were citing was the Allen and Conrad Inc. versus University of Central Florida case, 961 Southern 2nd, 1083. 5th District, decided in 2007. In that case, there was no certificate of occupancy, I guess because it was construction on state property. And at 1087 of the decision, it says petitioners contend that the architect for whom they were providing services completed his contract with UCF on April 24th, 1989, and that UCF took actual possession of the building on May 15th, 1989. No certificate of occupancy was issued as it was not required. The trial court concluded that the correct measuring point for the commencement of the proposed period under the statute's 4th prong was the latest date that any of the following entities completed or terminated the contract. So in that particular case, there was no certificate of occupancy. But the contractor had not completed. So the university occupied the building, began using it. Contractor wasn't done yet. And the district court, in reviewing that particular case, said, well, it's not going to be possession that is the prong that we're going to rely upon. Number one, we're going to rely upon the prong that talks about completion by the professional engineer, registered architect, or licensed contractor. So, and
Mr. Tannenbaum, you are at your rebuttal time now. You proceed as you wish.
okay. Yeah, and the court concluded, again, limitations defenses are not favored accordingly when there is a reasonable doubt as to legislative intent. Preference is to allow a longer period of time. So this, I don't think the statute's ambiguous. We have possession and title after or within the 10 years of the statute of repose for a group of homeowners in this community. The court did not reach beyond that to make any other determinations as to the impact of a portion of owners being within the 10-year period. I don't think this court needs to do anything but a narrow ruling that the summary judgment is overturned and to send it back to the circuit judge for further proceedings. It may come back on a different record for determining the implication of this, of a mixed bag where you have certain townhomes within the statute, but with a better record, the court can then make a determination on that if it comes back up on appeal. But you do not have a record, in our view, to support more than just reversing the circuit court and sending it back for further proceeding.
Okay. Thank you. You got about 3.5 minutes for rebuttal. All right. And did you say, Mr. Tozier, you're going first for 15? Is that what I recall?
That is correct, Your Honor.
Okay, you're up.
Good morning. May it please the court. Garrett Tozier from Schutz & Bowen on behalf of Appalachia Pulte Home Corporation. This court should affirm the final summary judgment in whole because the association commenced its claim after expiration of the 10-year time bar in section 95.11 3C of the Florida statutes. For these 196 improvements, 196 townhomes at West Park, we're going to be focusing on those 4 events in the statute that start the 10-year window. There's no dispute about abandonment. There's not been any challenge regarding completion of the contract, which was really the only issue in the Allen versus Conrad case that the association's counsel discussed this morning. There was no analysis on actual possession by the owner in that case, and there's no dispute about it here. For the other 2 trigger events, we're looking at the date of actual possession by the owner or the issuance of the certificate of occupancy. And the trial court correctly determined that Pulte was the owner. After completion of each improvement, Pulte actually possessed the improvement in the completed townhome. So therefore,
Well, let me stop you there, Mr. Tozier. Doesn't that interpretation of the statute create kind of an unworkable type ambiguity? Because, you know, let's assume hypothetically you've got a developer who owns, you know, the land, builds the buildings, and gets COs for some or all, and then for whatever reason can't sell them. So you're suggesting that this time is running that whole time. Buyer comes in, homeowner buys it like at year 9. And now they got a year to discover a latent defect before the statute of repose runs. That's your interpretation of the statute?
yes, Your Honor.
Since the statute talks about an action founded on design, planning, or construction of the improvement, couldn't we assume that the owner is not the one who designed, planned, or constructed the improvement as contemplated in the statute?
We would disagree with that proposition, Your Honor.
Well, of course you do.
No, but you are correct in pointing out that actually all 4 of these trigger events are tied to the improvement itself. And so that's why we need to look at the time period that the construction of the improvement was completed to determine who was the owner at that time period and when did actual possession first occur. And our summary judgment evidence showed that after each one was completed, or Pulte's field managers would be notified by the last subcontractor who worked on it. They would go over and actually then take possession of the final townhome. And so an interpretation that would use the purchaser would change the language of the statutory text because it just uses the word owner. And it would also create a situation where we have the statute running or restarting every single time the home is sold and then resold.
Well, no, let's assume though Pulte owns it and it wants to bring a claim. It gets sued by the purchaser, and Pulte wants to, third party, a sub, but it's been the owner and all this time, and its time has run. So is it stuck?
Yeah, we would say that the language of the statute supports that interpretation because,
keep in mind this OA is being recorded.
The buyer has recourse if it's a year later, 2 years later down the road, they can get a pre-purchase inspection, and the market will will account for the time lag. But otherwise, you'd be destroying the protections that the legislature intended in those legislative findings by creating an untenable situation where after the construction is completed, you're starting it for 10 years down, more than 10 years down the road, because those findings in the preamble are all focused not only on the completion of the contract, but they're concerned with getting insurers the ability to procure liability insurance, which was becoming impossible without an indefinite period of time. And so that's why there are certain circumstances where the purchaser would be not be the contractor, but the situation where someone buys a vacant lot and hires a contractor, that would be a situation where the contractor is not the owner. But in another aspect of that is that by focusing owner on the purchaser, we're really looking at the commencement of the action, the other opposite end of the time period. I think that part of the discussion with the association and discussing damages that's the wrong time period to look at, because that focuses on chapter 95.011 at the start of the chapter in the first section, we're looking at commencement of the action as based on who the association or who the buyer is. That's we think it's a unreasonable interpretation of the statute. The Herald decision is irrelevant on this. The Herald decision never decided that the ownership distinction question that was conceded by the parties on page 299 of the record. The only issue in that case was, did subsection 3C apply at all? Was an attic ladder an improvement? And in that case, so that's not dispositive of the question here. And Pulte's business intent with how their plans for the property should not be dispositive either. There's nothing in the text of the statute that suggests otherwise.
Mr.
And,
Tozier, I'd like to ask you a question regarding the initial portion of the sentence, of this sentence within C. In any event, the action must be commenced within 10 years after the date of actual possession by the owner. Florida is a record title state, a fact of which the legislature is, I think, under law presumed to know. So your client would be the owner. Does actual possession become a synonym for occupancy, or does actual possession in the statute some sort of concept that we might say in personal property possession, or how do we look at the word possession? Do they take possession of the improvement when the C of O is issued? What does take possession mean? Is there a statutory definition I should look at?
There's no statutory definition, Your Honor, and we took actual possession before issuance of the certificate of occupancy.
Well, how does a owner of land who builds a home on it take possession of it within the meaning of this statute? Is it by occupancy? Is it by getting the contract completed, which I know is another phrase in this statute? Is it by the government saying, you now have a property, you can take possession because we deem it worthy under our legal codes that we give you a certificate of occupancy? Is it become an external fact that creates take possession?
No, I don't think that analysis would apply for the definition of actual possession. We've used the term physical occupancy, physical control, the ability to exclude others. We just use the plain language of the text and the definition from Black Law Dictionary, like Harold did with the terms improvement and construction.
That have been Judge Lewis who wrote that one?
Correct. Yes, Your Honor. So yeah, it's the ability to exclude others. And so once the last subcontractor completed their portion of the work, that's when Pulte's field managers walked over and inspected and took actual possession of the completed construction. So residency and occupancy aren't the terms that are used in the statute, and we don't think there's any context to deem those items as part of what how this court should interpret that provision. Next, the general notion of looking towards the broader time and trying to discern the legislative intent from that perspective. That's a secondary canon of construction, only if there is an ambiguity. But if there is any ambiguity, what the intent is borne out by what the Florida legislature says. Any of the in their legislative findings, it's not to protect the homeowners. It's to protect the contractors from failed claims. And so we have express findings in the preamble that enacted it in 1980, reenacted it in 2006 when they shortened the time period to 10 years. And if we're going to rely on other canons of statutory construction, it would, the presumption against ineffectiveness, the replacing the term owner with purchaser would restart the time period every single time the home is resold. And in this scenario with the 196 townhome units, you'd have the early townhome purchasers, despite never actually possessing the 196 townhome, they would be being afforded a 12 to 13 year window. And the existence or the nature of homeowners associations in general shouldn't change the outcome either. The Florida legislature knows how to make exceptions They've done so for condominium associations in Chapter 718, but they have not made any sort of relevant exceptions here for homeowner associations. Also, their claims are not in the common areas. They're confined to the fee simple lots and the improvements on the townhomes themselves. And then the general notion of we prefer the longer time period, that only arises in the context of an access to court constitutional challenge where a quote unquote statute of repose, how it changes the relevant date from accrual as when the time period starts over to just some other date identified by the Florida legislature. There's been no assertion that there's been a statute of repose that has cut off any time periods before accrual in this case. So we're not concerned with the general notion that the Florida prefers longer time periods because there's been no allegation of an access to court violation here. So if this court is inclined to disagree with our interpretation, that we do think the summary judgment evidence is sufficient to sustain a finding on the early townhomes, 184 early townhomes, because all 4 trigger events, there's no question that each homeowner had actual possession of the 184 at least before February 12th, 2009. So in that circumstance, we don't, if this court determined that the owner is the purchaser, we'd only be remanding for the 12 late townhomes to proceed that happened after February 12, 2009. And summary judgment evidence record was clear on that. There was no attempt to show otherwise. We carried our burden under Florida's new summary judgment standard for the early townhomes. All 4 were completed. To remand for all 196 would defeat the legislative intent or in the text of the statute that requires a 10-year time window, because it would afford 12 to 13 years for the early townhome purchasers. So unless this court has any other questions, I will yield the remaining time to Lawson. And
good morning, Your Honors.
Thank you, Mr. Rowe. You've got about 7.5 minutes of time left. So use them.
Thank you. Thank you. Randall Rowe for Lawson Industries. I have just a few points. Pulte was the actual possessor of each unit before it sold each unit to a subsequent purchaser. And there is no way that the repose trigger can be measured by the purchase or occupancy by a subsequent owner, because if that's what the legislature had wanted, they could have just said that. And I believe one of the questions asked today was, what if there's an economic downturn and Pulte holds these units, for a number of years and then sells them to the unit owner? Is that inherently fair to the unit owner that they've lost years?
No, it's not necessarily inherently fair. It's what the legislature would have intended, when you use the term owner in this case, who bring theoretically, by your interpretation, this would be an owner, a developer bringing an action against itself. And
Well,
that action is extinguished.
Yeah, that's exactly right. The action is extinguished, and that's the point of a repose trigger, is that a statute of repose extinguishes a cause.
Oh, I understand about statutes of repose. The question is like, does the ownership in the developer chew up the statute of repose during that period of ownership before it's ever sold to the retail purchaser?
No, Your Honor, there's no language in the statute to support that. And frankly, if the developer holds it for a number of years, the developer has every right to sue its subcontractors if it starts noticing that there's defects in the home. So there are,
but okay.
Right. Yeah. If it notices defects, if it wants to, increase the purchase price by bringing a cause of action against its subcontractors or recoup losses of the purchase price because of those defects, it has every right to do that. And that's exactly why actual possession by owner has to mean that Pulte is the owner, because Pulte has every right to do whatever it wants with these units. And that's the Black's Law dictionary of actual possession, is physical occupancy or control over property. And Pulte met both of these categories in this case. It controlled the units to the fullest degree. It could house its employees in there if it wants to. It can sell them at any time it wants. It can tear them down if it wants to. And it has every right to occupy the properties physically in whatever manner it so chooses. And so the legislative intent had to have been actual possession by owner, meaning the owner of the improvement. And the owner of the improvement, as listed in each certificate of occupancy, was Pulte. you know, the delay for, you know, the sale to a unit owner, if there is a delay, that should not arbitrarily toll the statute of repose, because the legislative intent was to protect contractors from stale claims. Now, even if you do, you know, even if you do deem the subsequent transfer to a purchaser as the trigger, then only like 12, I think, of the townhomes here were sold less than 10 years from the date of the lawsuit. And that gets to the point that each unit should be deemed a separate trigger for opposed purposes. Each unit-
Mr. Tannenbaum said the lower court never reached the questions that turn on that scenario.
I believe that's correct, but if you reverse on the issue, then where does that leave us? We have everything, all the evidence, you know, in the record is ready, and it would be a waste of judicial resource to go and relitigate this issue before the trial court. I think each unit was given its own certificate of occupancy. If you adhere to what the appellant's argument about the single project rule, then you have a problem where if you have a purchaser of a 2006 unit in 2006, and then you have a purchaser of a unit in 2009, well, the 2006 purchaser has a 13-year window to bring a claim. The 2009 purchaser has a 10-year window to bring a claim, which is why you cannot measure the repose period from the date of the last unit in a project, when every unit can be occupied on a rolling basis. This is a problem that we're experiencing in Florida with these mega subdivisions that are developed in phases, and each separate phase is a separate lawsuit. This single project rule that the appellant is arguing for, and which they actually filed supplemental authority on just last week or 2 weeks ago from a trial court ruling, it can't hold up in the law. But regardless, actual possession here, it was triggered by Pulte's ownership by the plain language of the statute. The statute does not say anything about a subsequent sale or a subsequent purchase. Pulte's ownership of all 196 units coincided with the issuance of the certificate of occupancy, and so the entire claim is barred. Thank you.
Okay. Mr. Tannenbaum, you're up for rebuttal.
Let me give the most extreme example, and Judge Northcott, this is kind of following your example, because you only took it out 9 years. Let's say Pulte built a development and for whatever reason decided not to sell the first unit for 11 years. But under their interpretation, statute of repose is already run, and it could then sell to the original purchaser's defective units or townhomes without any repercussion, because the statute of repose is already run. So that's the absurdity of the argument. We have never alleged that subsequent purchasers, subsequent homeowners, if somebody sold their unit 4 years later, that starts the statute of repose again. We're not arguing that at all. We're talking about the original purchasers from the developer who developed and constructed these residential buildings. So so there's no confusion on that point. Would not take that position. As far as the judicial economy, my understanding of appellate courts is that they only make, or should only make, decisions based upon an appropriate record. The circuit judge decided this case on a very narrow fashion. I'm deciding this case, I'm interpreting statute of repose as saying that Pulte, upon getting the certificate of occupancy, was also the owner. And there's really no reason to have that first prong, because certificate of occupancy rules, but that's not what the statute says. That's what the circuit judge determined. There's a lot of judicial work to be done back at the circuit court level to fill out this record, so that if we happen to again come back before you again with an appropriate record and appropriate argument, you can make a decision about, if it hasn't already been decided by another district court, you can make the decision about how does the fact of this date sequence, where Some of the units are definitely within the statute of repose. Those owners have an obligation to repair and maintain the entirety of the property. And there are these assignments. How does all that impact a determination on the property as a whole? The circuit judge has not reached that. So again, our request is a very narrow ruling by the court that the circuit judge was incorrect in the interpretation of the statute of repose as applied to this case, in the sense that those ownership is determined when a purchaser from Pulte actually takes title to and occupies the first purchaser takes title to and occupies the unit. And again, we may be back, but you do not have the record to say more than that. We did not, by the way, file a cross motion for summary judgment to have a decision that we're within the statute of repose on all the units. We did not do a cross motion for summary judgment. So we're not even looking for a ruling in our favor on that issue because it's not before the court. So,
Well, you know, I tell you, and that's your time's up, Mr. Tannenbaum. And I will point out that when people talk about, you know, judicial economy is kind of a trope. They fail to mention that, you know, you get what you pay for. So that's the end of that case. Now we have some of you on the next case as well. So we'll take up, you know, what is it called? We'll take up Pulte Home versus West Park Homeowners Association. So, and I think Mr. Tozier, you're arguing for the appellant in that case.
That is correct. And I'd like to reserve 5 minutes for rebuttal.
Okay, and Mr. Rowe, you're arguing for the appellee?
Yes, Your Honor.
What are you doing, Mr. Tannenbaum? Are you done? You're muted. You're muted, Mr. Tannenbaum. Oh, there you
yeah,
go.
there you go. I think so.
Yeah, I think so. Okay. So I think that I think you can leave. I'm welcome to hang around if you want, but still watch it on YouTube if you want. And you leave by clicking